what can I say? Good morning, good afternoon, and good evening. So
good evening for everyone over there.
Yeah, it is a great pleasure that we are all together here and from literally across the globe. So I think this is the unique element of this specific webinar, having so many great colleagues, corporate lawyers from so many jurisdictions speaking about their experience, especially during those days where, you know, the pandemic, the social distancing, and in general, the situation now with COVID-19 has affected apparently not just our lives, but also our business. So it's time to see where we stand at the moment and what we can expect in the coming years. Before I start, I should say many thanks to Amblex 365, which is presenting this webinar. The company's experts in anti-money laundering softwares. I should also send many thanks to the University of Nicosia for supporting this event, and definitely to all those people that they register for this event and they show their interest about the topic today. Now, before we start our discussion, let me first introduce my colleagues. And I should start from the ladies here, and starting from Diana Cuevas, who is based in New York, in USA. And Diana is managing partner at DC International Law. She has more than 15 years of experience as international corporate lawyer with expertise in international contract law, technology transfer, real estate, and I would say especially in mediation and arbitration. She is also currently Vice President of the International Chamber of Commerce, Arbitration and Mediation Committee. Hi, Diana, and thanks for joining us. Maybe you should just switch on your microphone.
Thank you for having me. It's my pleasure to be here.
Thank you, Diana. Eleni Polycarpou, she's coming from London, UK, partner and co-head of international arbitration at Withers LLP, one of the biggest law firms in the UK, and not only. Eleni's expertise is in international commercial disputes, with particular experience in commercial fraud. She has many years' experience litigating before courts and arbitration tribunals. Hi, Eleni.
Hi, everyone. Thank you for having me. Hi.
It's my pleasure. Now, I have to say that it's particularly emotional moment that I have to introduce two old friends now. We were together back in, I'm not going to say the year, but in Nottingham, back in the UK, doing our master degree in international commercial law. Samuel Uziel Rivero Prados from Mexico and Puneet Arora from India. Samuel is currently Senior Financial Associate for Bello Gallardo Bonecchi Garcia law firm, based in Querétaro, and offices also in other cities in Mexico and Spain, if I'm correct. Samuel is also President of the Board of Directors of the Energy Cluster of Querétaro and President of the Board of Directors of the National Association of Corporate Lawyers in Querétaro, and his expertise is in financial law, banking, and global markets, with experience also in legal and compliance matters. So, Hi, Samuel.
Hi, Charis. Thank you very much for the invitation. It's a great pleasure to meet you here. Thank you very much.
Last but definitely not least is Puneet Arora, founding member of Arora & Co., a law firm based in India. I think that in Mumbai and New Delhi, correct?
Yes, correct.
Yes, and Puneet's expertise is in mergers and acquisitions, private equity investments, joint ventures, technology transfers, foreign investment, company contract, and insolvency law. Forgive me if I forgot something, Puneet, but it's an outstanding CV. Thank you very much for joining us.
Thank you, Charis. Thank you for having me.
Yes, so definitely this is a topic that it's hard to be covered in just 1 hour. So apparently we are going to touch only on topics that definitely attract the attention of the legal sector worldwide, such as the contractual issues that we are facing nowadays, and especially I'm talking about force majeure clauses and other situations which forced contractual parties either to, not perform their obligations under the contract, and this led or is about to be resolved before arbitrations, before courts. So this is also takes us to another topic, which is the alternative dispute resolution mechanisms and how these mechanisms possibly attract new interest, I would say, nowadays, especially since the developments that we had in mediation and Singapore Convention. So things that we definitely cover later on. E-justice, new technologies are always there, particularly nowadays where we need to work, all of us, we need to work remotely. So we are getting more and more familiar with virtual hearings and anything else that definitely is not the type of justice that we learned back in our universities, but definitely it is what we have to become familiar nowadays, and definitely we need to improve and we need to develop. So I'm just giving now I just gave some of the key topics that we will discuss in the next hour. And let me now move to the questions that I would like to address and open up the discussion. So I will start with Eleni and with a topic that definitely is on the top of the agenda. Businesses have been facing apparently serious economic challenges in recent months, especially in relation to contracts performance. So, Eleni, what kind of contractual issues have you seen arising during the pandemic?
So it's not going to be a surprise to anyone to hear that the pandemic has had a very significant effect on parties' ability or willingness to meet their contractual obligations, which they made under normal circumstances. And so some of the key issues I've seen are that a lot of businesses have come to us and they've said, we need to change the terms of the contract. We need to renegotiate the contract. And so we have assisted businesses in their discussions in the retail sector, in the hotel hospitality sector, in the supply of goods and services. All those sectors have had to go and speak to people like their landlords, for example, to renegotiate the lease agreements following the lockdown and things like that. A lot of people have engaged in very good discussions and have renegotiated the contracts. but some have not. And on those occasions, we've had to look at their contracts and see whether we could terminate them according to the termination provision in the contract. Now, I'm going to touch on this a bit more later on, but for example, insolvency is not a ground on which you can terminate a contract. And so then you start looking at elsewhere in the contract, and you look at the force majeure clause, and most commercial contracts will have what's called a force majeure clause. In England, we don't have a doctrine of force majeure like they do, for example, in civil law jurisdictions like in France, which, I think they invented the concept. So it's just a matter of contractual construction. And so when you look at the force majeure clause in the contract, it will depend entirely as to what it says as to whether you can rely on it in the pandemic. It's intended to protect you if from a breach of contract claim if you anticipated the type of event that came and you're unable to perform your obligations as a result of it. And very crucially, it doesn't bring the contract to an end. It simply suspends it for the duration of the event. Now, that's a key difference between that and claiming frustration, for example. And so if you look at the force majeure clauses, they are interpreted very restrictively in the UK, in England. Some key points that are important on this are that like I said, it should have been in the contemplation of the parties when they wrote the contract. So even if you're reading a force majeure clause and it looks as though it covers the pandemic, if they hadn't anticipated it, the other person could still get out of it. If the clause says that the effect of the event is that it prevents performance, you can't rely on it just to say that, look, it's no longer economically viable for me to do this contract and therefore I'm claiming force majeure. That doesn't work either. And finally, on causation, you have to be able to show that the supervening event was the absolutely sole cause of the non-performing party's inability to perform. It wasn't, we had financial troubles before the pandemic and now we've got even more financial troubles. That, again, won't work. If the force majeure clause doesn't help, then you go to frustration. Now, frustration is described as a nuclear option in England because it puts a stop to the contract automatically, and it stops anyone from claiming damages, and says that it's because of a supervening event for which neither party is responsible and which was not contemplated or foreseen by the parties. You can't use frustration to get out of a bad bargain, for example, like before, and it's construed very narrowly. I think in England there'll be lots of cases coming through the courts in the next months which will develop the law in this area. But just to give an example on something I'm dealing with at the moment, I have a client who booked a holiday, and she booked a private yacht to go on this holiday, and just the day before she was due to travel, she was told that the rules changed and she couldn't travel to get on the yacht. We looked at the contract. The force majeure clause didn't protect her. It protected only the owner. And so then we looked to frustration and we said to the owner, this contract is frustrated because of government regulations stopping her from traveling. And the owner is saying, well, actually, you should have anticipated this and therefore no frustration. And so we're having this argument at the moment, and we'll see who wins. But that's an example of something that's going on at the moment in my books.
If he was in a position to anticipate this, maybe we should engage him or her in another position.
Yeah, exactly.
Okay.
A wizard or something. Yeah.
Yeah. Thanks, Eleni. Definitely, we'll get back to the court procedures and arbitration, how all these things we expect to end up in judicial proceedings. Now, my second question goes to Puneet, and it will be really interesting to see what has been the effect of the pandemic on contractual obligations in India. How is force majeure applied under Indian law?
So like everywhere in the world, even India has been severely affected by the COVID-19 and related lockdowns. In fact, in India, we have had the widest, the strictest, and one of the longest lockdowns in the world, and which has directly impacted the capability of parties to perform the contract. So it has led to difficulty, if not impossibility. So we have seen requests for renegotiation of the contracts, but lastly, we have seen requests for either temporary or complete suspension of obligations under a contract. And all of those arise from force majeure. So India is also a common law jurisdiction like UK. So our law is also somewhat similar to UK when it comes to force majeure. So force majeure per se is not a defined term or a codified term in any of the Indian laws. But the genesis of force majeure is under the codified Indian Contract Act. More specifically, two provisions. One is Section 32 and one is Section 56. So the earlier section refers to the contingent contracts. So which provides that if there is a contract to do an event on happening of a certain unforeseen event, if that becomes impossible, so the performance of the contract becomes impossible. But the Section 32 of contingent contract is only applicable in case there is a written force majeure clause in the agreement. If it is not, then we also have to seek protection under Section 56, which is frustration of contract. So, sorry, in contracts where there is an express provision contained with a force majeure clause, so we'll have to see the specific clause, how it is written, what are the events which lead to a force majeure, and the consequences of it. So there is one very important principle under Indian Contract Act. The contract is sacrosanct. So if the parties have written a force majeure clause in the contract, even though it might be limited, the court has to give effect to it and not imply anything additional in addition to what is written in the contract. So force majeure cannot be implied in a contract. So therefore, how the clause is drafted, the consequence becomes of great relevance. But if there is a force majeure event which is dehorse the contract, that is, which is outside the contract, so we have to claim frustration. Now, to claim frustration, there are three important elements which one has to prove. One is that there was a contract was yet to be performed, and it became impossible or unlawful to be performed after execution without any fault of the parties. So once these three thresholds are proved, then one can claim frustration of contract. But frustration of contract is also very difficult to prove in a court of law. It does not automatically relieve the party from performance of obligations. You have to prove it in a court of law. So to prove frustration of contract, the bar is very high. The court sees it very objectively, not what the parties would have anticipated, like it's in the UK or how Eleni said. The court sees it very objectively whether the event which has led to impossibility of a contract or under which the frustration is claimed changes the very fundamental nature of the contract. If it does not, then there is no relief which can be sought on the basis of frustration of a contract. So in these recent times, whenever we get requests from parties to either temporarily suspend or permanently suspend their obligations under a contract, the first and foremost we look at if there is an express written clause in the agreement. And then we see the scope of it. If not, then we evaluate based on the business, based on how it is impacted, whether impossibility or frustration can be claimed.
So force majeure could be an argument even though it is not written in the contract, or you go straight to frustration only.
we go straight to frustration. So if there is a written force majeure clause, then it has to be narrowly interpreted, strictly in accordance with the language. If it is not, then we go to frustration.
Okay. Thank you, Puneet. Diana, I'm sure that in a few months, everybody's going to ask you what is your opinion with the U.S. elections, but for the moment, let me ask you something different. Because, okay, you have this expertise in mediation and arbitration. What do you think? Do you think that the pandemic is somehow reshaping the alternative dispute resolution mechanisms? I mean, it changed the way that we know them. They become more and more preferable, or not? What do you think?
As well, there's been a lot of discussions since the beginning of the pandemic regarding the contracts, breaking the contracts, fulfillment of the contract, as my colleagues just said, the force majeure of the contract, frustration, and all that kind of thing. What we're trying to do, and we're trying to move more towards to settle, instead of going to litigation and battling this and trying to see whether it's force majeure or it's not, and who's going to pay for what. And this could take, as we know, X amount of time and money. So we're trying to solve the problem, solve it as quick as possible, solve it as amicable as possible, and to keep the relationships. So what is going to be the new normal? Look, we've all been taken out of our comfort zones as regular ways of doing things as we know it. And although mediation has been available for a long time, it's still fairly new in terms of international dispute resolution. Unfortunately, the pandemic has disrupted business and social environments in ways that we could not have imagined ever. This is way beyond anybody could ever expect it, right? So we can expect that dispute resolution to become the new normal in many cases, and both in its online and offline forms. It seems we've fast-forwarded for about 5 years in terms of market willingness to settle arguments online. You know, once parties discover the convenience of it, they will likely to continue to make use of it, even after international travel has opened up again. And I'm sure we can all agree to this. I mean, it's much better to, instead of, you know, getting on a plane as an attorney and having to go abroad to litigate the situation, we can do it from the comfort of our home and have it raised for it to be enforceable. Now, for example, the Singapore International Mediation Center has launched a protocol for COVID-19 to actually do this, to provide an expedite route to resolve international disputes during the pandemic. So if one realizes that actually this is possible to be more effective and efficient, it is likely to continue like that in the future. And why? Well, since the economic impact of the COVID-19 on business and commercial parties can be felt across the world, like, as I said before, unfulfilled contractual obligations, supply chain, logistics, cash flow, employment issues. We have no other option but to look to better and faster dispute alternatives by digital means. To do this, we do have to embrace and be more millennial, if you will, to embrace remote communication technologies and be more open-minded as to negotiation, as I said earlier, to reach an agreement. In other words, we have to be more effective and flexible during the business to the new normal, not only willing to continue the business, but to actually be flexible enough to keep the business going. And I said, we have to be effective, efficient. That answers your question.
No, yeah, I mean, you're right, and I share the same opinion like you, and this is the way that I think, that I see things moving. But definitely, we have more developments to discuss, especially with the Singapore Convention, and we will get back to this later to tell us what is your opinion about this and how and what's the connection with the New York Convention and how things will change in the business world. Now I'm going now to Samuel. Regrettably, Latin America is now the epicenter of the pandemic. So as far as we can see, and from the news, is now the situation. I don't know if it reached the peak or not, and where is the curve, but hopefully it will get over this very quickly. So I'm saying this because given that all these problems that we discuss, the complications from lockdowns and all consequences, negative consequences, had already been seen in Asia, then Europe, and it seems that America is the last continent to experience these difficulties. And given that you had this clear view of things, how it's getting worse and worse, how quick was the adaptation of America to these legal challenges?
Yes, thank you, Charis. Interesting question. Yes, as you said, even though America was probably the last continent to face the pandemic, as you said, it started in Asia and then Europe. But even though it was very quickly the spread of this disease, of this COVID-19, in just 2-3 months, it spread all over the world. So we had, as you say, an advantage of maybe 1 or 2 months in regard to Asia and Europe. And unfortunately, we didn't see it as, until you experience it, you don't really take many provisions. And fortunately, not even our governments and not even ourselves as society took it, as serious as it really is, So we just had maybe 1 or 2 months time of advance to get prepared, but we really didn't took any measures on that. But the thing is that it has to all over the world. It has brought a lot of changes, and these past few months we have seen accelerated changes in the way of doing businesses, in the way of practicing law, as all my colleagues before have mentioned. All these new technologies, all these new dispute resolutions, and all these things that we are experiencing right now. This was not new. All this technology, all these new means of communication already existed before the pandemic, but it has forced all of us to use them in an accelerated way, because otherwise it would take more time to implement in the practice of law, in the practice of businesses. So it has forced all of us to accelerate these changes, this implementation. Otherwise, if we wouldn't be forced to use them, it would take more time to use these new technologies. So even though we were not well prepared as we could have been before, it has forced all of us in America and all over the world to the use of new technologies, to the use of new ways of businesses, as Diana was mentioning before. We need to look forward and need to adapt ourselves, our ways of life. We have been affected tremendously, and the businesses and the practices of law. So it's something that we are all experiencing worldwide, and it will change the world, I would say, forever. It's not a change that will take place only for a few months, and then we will back to the way we were before. We will be affected tremendously, and we're just starting to see all these effects. Going forward, will change even more, I would say, in all our business practices, our law practices, our daily lives. So
yeah, I completely agree with you, and I would say that all these, the new concepts that we experience now, remote work, virtual hearings, all this stuff, it looks like it's not just a necessity of, today necessity, but at the same time, it seems that we all like this more.
Yeah.
I mean, it's more, yeah. But so I think that okay, this definitely bad experience with the pandemic. At least it will left something behind, which is we can build on this. I mean, in order to make our jobs and our work more efficient, maybe.
Yes, correct.
Elena, I'm coming back to you, and since it's UK and especially London and England is a center of commerce, and because it's obvious that most of the jurisdictional clauses in contracts have English courts as the form of there's jurisdiction to interpret and bring legal proceedings in case of breach of contracts. What has been the impact of COVID-19 on the conduct of legal proceedings in the UK? And especially, what is your feeling or your experience about virtual hearings?
So, just to give a short timeline, so on the 11th of March of this year, COVID was declared a pandemic. On the 15th of March, the English government said to avoid non-essential travel. And on the 23rd of March, the whole country went into complete lockdown. During those 2 weeks, the English courts were preparing for this crisis. And so when we went into lockdown on the 23rd of March, the whole court system, both civil and criminal, stayed open for business. There's been no closure at all. In the civil system, the rules already gave judges the ability and the power to hold hearings by telephone and receive evidence from witnesses by live video link. We were already doing that. But they just put in place a system of public broadcasting so that you can actually log on to YouTube and watch live the Court of Appeal and Supreme Court hearings going on right now. And they reacted unbelievably quickly in order to continue. And they've recently published, the Commercial Court last week published a paper that said that there's been no backlog as a result of the pandemic at all. It has really been business as usual. My own team, in the first 2 weeks of lockdown, applied for freezing injunctions in 3 different cases. We had the applications heard remotely using different video platforms, and we continued. And as you just said, as you just discussed with Samuel, actually, these kind of interlocutory hearings work very well online because it saves money for the clients because there's no travel time, there's no waiting time. You're just straight on to there. You've got the judge, right there on your screen, and you're looking at him, and you can see his reactions close up, and you can see whether you're doing well or not. And we like it, yeah. I can't see.
Do you also see the dressing code?
Yeah, I mean, they have to wear their wigs as usual. It's all just, it's amazing. And so the court buildings closed to the public initially, but now they're open. And at the moment, I don't know if you've seen, if it's been published around the world, but at the moment, we're enjoying a daily cover of the Johnny Depp versus Amber Heard trial. you know, a daily diet of the whole intricacies of their relationships. And it's amazing. It's going on live in the High Court. They've occupied 5 different courtrooms because they're doing all the social distancing. So they've got the lawyers in one room, they've got the journalists in another courtroom, they've got the public in another one, and they've got video screens connecting everybody. And we get to hear every minutest detail, much more than we would have done if it was business as usual, I think.
Where can we get the passwords to join the session?
Well, you can, if you just go onto the Daily Mail website, you get a very detailed run-through. There's no doubt that the past few months have transformed the English litigation, and they have accelerated what was already going on in a massive way. And the same has happened with arbitration. In fact, the arbitration world was already ahead of litigation, and now they've really skipped ahead. There's one thing that I would recommend to any kind of litigation lawyers out there, and this is reading this Seoul Protocol on Video Conferencing, which was published by the Korean Arbitration Center in March, which has very detailed guidance as to how to conduct video hearings. And the other thing that's happened is this collaboration between different arbitration institutions to continue after the pandemic with what they call global hybrid hearings, which is few people in the room and a few people on the VC, and just making it more practical and more accessible to more people. So I do think that this is a positive. If there's anything positive to take out, then this probably is it.
Thank you, Eleni. By the way, we have a first question coming from Nida, and asking what's the success rate in online arbitration. Well, I mean, this is something that's too early, I think, to get some, statistics on that. But it depends on whose side you are in order to speak about success, definitely. Because somebody loses. Okay.
Yeah. I haven't. I have heard of many people trying to avoid going to a hearing and using the pandemic as an excuse, and the tribunal saying, no, you are going ahead. We had a case which was a 3-week trial in June in my team. Some of the witnesses were in Ukraine, in the remotest parts. They had no internet. And still, the tribunal said, no, you're going ahead. And we went ahead, and it worked very well in the end. So, I think that if by success rate you mean how many hearings have gone ahead, I would say I haven't heard of any being cancelled.
Yeah. No, definitely. It is a very interesting question, and we're all looking forward to get some statistics on this, because definitely show the way in the future. So yeah, correct. Let me take you to a slightly different topic now, and my question goes to Puneet, who has the experience with cross-border mergers and acquisitions. So, what are the legal and practical issues for mergers and acquisitions in COVID-19 era?
As far as merger and acquisitions are concerned, the initial reaction to COVID-19 was absolute knee-jerk. So the transaction almost came to a standstill. We have seen a bit of revival, but still the pipeline is very slim as of now. Like we had force majeure clause in contracts, so in all transaction documents, we have a clause which is called the material adverse effect clause, or a material adverse change clause. So parties where the deals were concluded, the transaction documents were signed, but now since the outlook to business has changed, is utilizing the material adverse effect clause to see if the impact has been severely negative, the valuations have gone down, and they don't foresee a quick recovery in that sector. They prefer to walk away from the deal. So that is the main challenge that we are facing these days in the transactions which have been concluded. So now in this scenario, the material adverse effect clause has in fact gained much more relevance, that in future deals, it will have to be much more exhaustive to assess how the impact would be on a particular business, on liquidity, and if such a pandemic situation continues for long, or if it goes away and another pandemic or some other force measure or a very significant event comes and distresses the business, then how is it going to be used? Mm-hmm. And I think what the request that we are getting is that now, at the very initial stage, at the stage of LOI or a term sheet, which is the absolute beginning of a deal, parties are negotiating the material adverse effect clause so that they don't, after spending a lot of time, have to renegotiate it at the stage of transaction document, after spending a lot of money. The second very common request that we are seeing is extension of timelines. And that goes for all the stages of the deal, whether it is pre-transaction negotiations, the conducting of due diligence, the negotiations about the transaction documents, or the closing conditions. Because more often than not, a merger and acquisition, especially a cross-border one, requires some kind of regulatory approvals. Now, the government, the regulators are also working at a reduced capacity. So it is taking time to get approvals, regulatory approvals. Then in India, in certain kind of acquisitions and mergers, you also require a court approval. Now, courts are also working at a very limited capacity. They are hearing urgent interlocutory matters as a initial, relief to be given to the parties, then mergers and acquisitions. It is not that they're not taking up mergers and acquisitions, but it is still not as quick as an interlocutory urgent application. So therefore, the timelines are getting delayed. The third thing that we are witnessing is the approach to valuations. So the deals which have already been signed, the transaction documents have been signed, and parties still intend to go for closing. So more often than not, there is a clause which for price adjustment at the stage of final closing. If there is an impact, so the final price, final consideration that is payable to the buyer may be subject to change. So the valuations are being impacted. Similarly, for deals which are at the negotiation stage, so there has been a complete change in outlook how to arrive at valuations because of sudden disruptions. There have been disruptions to supply chain. There have been disruptions to employees. There have been stock which is not adequate, or the repair or the spare parts of machineries are not available. So the entire concept of valuation is undergoing a tremendous change. Mm-hmm. The fourth thing that we are experiencing, and which is very significant, is the way we do due diligences. So due diligence, while you can get documents in a virtual data room or online, but there are many aspects of due diligence which you have to do it on site. The physical verification of stocks, the inspection of original documents. So those are not being able to be completed in time. So it is also leading to extension of time or limiting the entire due diligence exercise. So once we limit the due diligence exercise, then necessarily we have to place reliance on representation and warranties of a party, because we are accepting on the face of it what they're telling us about a particular document or a physical stock. So we are seeing much more exhaustive representation and warranties and consequent indemnities. So if from the date of signing of a transaction document to closing, the representation and warranties are not true anymore. Yeah. So either the deal could be cancelled, or then the seller, the buyer can seek indemnity. Mm-hmm. So there's a good focus on representation and warranties to be very exhaustive. And again, we are again seeing bit of it at the LOI stage itself, so that going forward, the crucial terms are already agreed, and after spending a lot of time in due diligence, the things don't go south.
Yeah. Well, definitely. Also, the whole due diligence exercise, it's also getting a new shape in the new situation. I'm moving now to Diana, and I want to ask you about international business disputes and whether settling international business disputes now pass through arbitration or mediation more frequently or not, or what do you expect to change in the near future about this?
Well, as I said before, I think we're going to move more towards dispute resolution. And we have, as Eleni already has described, we have arbitration and we have mediation. The problem here is that mediation per se, it might be a little bit in a gray area for now. It's relied upon the Singapore Convention. And in my opinion, and this is just my very personal opinion, and I'm sure there's people that might not agree with that, but in my opinion, the Singapore Convention is right now more a step towards establishing a diversified range for dispute resolution options for parties internationally. So I think it's fair to say that it's still premature to consider whether the Singapore Convention will be universally adopted, and if it is, will it encourage parties to resolve international disputes by means of mediation? Hopefully, yes, since it was introduced actually to provide a harmonized framework. It does, though, directly address the main problem of mediation as a dispute resolution forum, which is the lack of enforceability as a binding and enforceable process. So I think we will see more acceptance to the convention. However, the convention does have a few issues for its enforceability and applicability. It's still fresh, thus it leaves a lot to the national laws for its enforceability. So it's not as unified as arbitration. For example, in Brazil, we know what the process is going to be for arbitration, just like it's going to be, for example, in Japan. It's something like, going to McDonald's. It doesn't matter where in the world you are, you know exactly what you're going to get. But with mediation, it's not exactly like that. So it initially was to create confidence among the parties to settle the international disputes. So the signatory countries will actually enforce it without a further litigation. The problem is, I think currently the convention is more aspirational than operational, given its exclusions and exceptions. And what am I talking about? There's a lot of exceptions in the Singapore Convention that won't fly in the New York Convention as arbitration. So they have a lot more room to whether apply it or not apply it. We know, for example, that any other contract that has to be in writing, signed by the parties, signed or certified by a mediator, but this creates an issue of, for example, confidentiality, which is key for a dispute resolution that is outside court. This conflicts with common practice. Why? Because we want to avoid being subpoenaed regarding the execution of the agreement as mediator, right? And avoid being considered part of the party that rights and obligations of the agreement. So we merely have to affix a signature to verify that a mediation took place, and then we can satisfy actually the issue of accountability as a mediator. Now, the other issues of the conventions are exclusions. It's very new, the convention, so I'm sure this is going to be polished in the future. The convention also excludes from coverage those relating to consumer transactions, family, inheritance, employment law. Of course, if it's enforceable as a judgment or arbitral award, which is obviously to avoid an overlap with the New York Convention or the Convention of Choice of Courts, which is justifiable, correct? But now, statewide, the convention permits signatory states to make two prescribed reservations at the time they ratify. One is, the state will not apply the convention if the state is a party or entered by the government agency or agents of a government agency. Well, which doesn't happen, of course, with arbitration. Another one is the convention will only apply to the extent the parties agree to, which means a state can ratify and at the same time opt out. So what is that? Is it really an enforcement mechanism? A big concern is that it fails to provide the means to enforce the settlement because it does not set forward the actual means for enforcement. Enforcement is left to the jurisdictions where the parties choose to enforce the settlement. So, you know, one has to, you know, really think whether you want to mediate or arbitrate. But again, if we go to arbitration, we can do a hybrid. So we can start arbitrating and then go back to the mediation and then have it awarded as an arbitration award if, you know, if we do ARB met ARB or some kind of, you know, hybrid procedure there. You know, also, it's important to point out that if a state refuses to enforce a settlement arising from mediation, if a party, listen to this, if a party furnishes proof that there was actually a serious breach by the mediator. Okay, so who actually says what are the standards for a breach in the process as a mediator? Okay, so we can actually go to codes, institutional codes, doctrines, the ICC, but they don't actually define what would be the conduct and the standards for a mediator, which then, again, of course, as a mediator, I'm like, well, I don't even know if I want to, you know, speak up my mind or do anything that it might be considered by a party as I breached the standards. Whose standards, right? I mean, this is global. I'm sure that people in India have different standards than we have in New York because we're very neurotic. So just imagine that.
Who's going to decide? Who's going to decide about this? I mean, if the mediator breach.
Well, no, the state where it's going to be enforced, and that's what I was saying. The state can actually refuse to enforce if one of the parties comes up with exhibits and prove that, oh no, this mediator breached the standards or there was a serious problem in the process, and then they go back to basically the national law, whether they would consider that to be a breach or not. So that's a little, you know, again, it would breach also, or it would interrupt the principle of confidentiality, because then do they have to bring witnesses to attest this? So now we don't have confidentiality. Does the mediator have to be subpoenaed? No, so now we don't have confidentiality. So do we actually have, is it an ideal forum? I'm not saying it's not, but we still have to iron a few things out there, right? So there's another issue that troubles me, which is, you know, the standards. We do have to harmonize. It is a forum that wants to harmonize all these issues. So we're a little behind, definitely, you know, far behind from New York Convention, and maybe you know, maybe I have, maybe I don't have time to talk about the differences, which are very interesting, but we will get there eventually.
Yeah, I was about to ask you later, I mean, how responsive you think that the mediation convention is going to be, but I think I got the answer already. So maybe you can say.
There's actually many factors that differ from the New York Convention and the Singapore Convention. They're different. Again, this is mediation, it's not arbitration, it's, you know, that kind of thing, but still things that could be leveled at some point.
Okay, great. So I'm not going to ask the question I was planning to ask, but definitely I will give you the floor for the concluding remarks, if you like.
Okay.
But give us at least something positive.
No. That's what I said. It's not my opinion, and I'm not trying to throw the convention under the bus. It's great, and it's something that we can utilize definitely, and it's going to take us a step forward, as I mentioned before. However, if for example, me as a mediator, I have to work with the Singapore or under the framework of the Singapore Convention all the time. Of course, case by case, we're going to run into these issues all the time. So the more we do it and the more we apply the Singapore Convention, the more things, and I'm sure this happened, you know, I'm not that old, but I'm sure that happened in 1958 with the New York Convention for arbitration. And it's been amended a few times, and that's what's going to happen with the Singapore Convention. So eventually it's going to be the ideal form.
All right. Very nice. Samuel, okay, I mean, speaking about business law, definitely the next thing that everybody has in mind is what about the financial sector, financial services? So what is the perspective of financial services in the coming years?
Yes, thank you, Charis. As I was mentioning before, this pandemic, these lockdowns have accelerated the use of information technologies for all of us. This webinar is an example of this. And also financial services is taking that path. As you know, in Mexico and many other jurisdictions, there are fintech companies operating already. That is financial companies that are providing financial services, technological companies that are providing financial services. That's a fintech, and probably most of the people watching us are familiar with some kind of fintech companies in their jurisdictions. Some jurisdictions have set up a legal framework to regulate these fintech companies. One of them is Mexico, UK, and many other jurisdictions have already issued some regulations on fintech companies. So this is providing new players into the financial system all over the world. And this is encouraging and fostering competition because, as you know, financial services, financial institutions were provided only by a few international banks, some major banks in some regions or jurisdictions, but at the end were few players in this sector. Nowadays, we are looking for growth in competition due to these fintech companies. And also we are looking at a new trend that is open banking. Also, some jurisdictions are starting to regulate this open banking, which means that all the participants in the financial system will need to share some information in order to have, you know, a more level ground for playing. Let's say now all the banking financial institutions and these fintech companies will need to share their services, their characteristics of their services, will need to share transactional information on an aggregated basis. You know, you need to keep the confidentiality of the transactions of your customers, but you need to provide the aggregate information of all the transactions being done by your institution, your company, and some other of this big data information on financial transactions and financial information will need to be shared now by all the financial service participants with other actors that were not relevant before. All these technological companies that manage this big data, such as Google, for instance, or some other Apple or other technological companies that will, if they want to, they can access to this information and provide, you know, an information, a solution suitable for each customer. Let's say if you're a customer that wants to open a deposit account and want to make some financial transactions, instead of going to each financial banking institution, to each financial services institution, you can have this information, let's say in Google. You will Google what is the best deposit account for me for, let's say, $10,000 average of transaction. Google will provide you the best options for you, so like it's happening for other services. So this is what is going to happen. Well, it's already happening in many jurisdictions, and we'll see an acceleration of that kind of process of big data analysis now into financial services. So it will bring, of course, advantages to consumers, but it poses the risk of cyber attacks, of hacking, and so it has to be set forth a set of rules in order to protect this information from hackers, from misuse, etc.
Yeah. I think you're right, and this is something also that I'm looking at nowadays, because, speaking about multinational companies, huge corporations having millions of clients, customers, users, Facebook, Google, Apple, all these giants, you understand how things will change if they decide to make an entry into the financial services, and if they want to take advantage of the electronic transactions and creating maybe an ecosystem within their clients where they get their own. I'm speaking also about the tokenization and this kind of stuff that definitely will change the way that we used to see the market.
Yes.
All right, since we are running out of time, let's have a quick turnaround and have also a sort of concluding remarks from each of you. I want to address a question to Eleni about the new corporate insolvency measures brought in the UK, whether these aim at giving a sort of relief to businesses or not. Because this is a topic that, as far as I know, it attracted a lot of attention in the UK. So what's the situation about this?
Yes, you're quite right, Harry. This is a really hot topic in the UK because as at 30th of September 2020, all the interim measures that were about suspending proceedings or insolvency proceedings, etc., come to an end, and everyone's thinking, what's going to happen afterwards? Is there going to be a huge economic crisis? Are there going to be businesses that go under? What's going to happen? And so, so what the government has done is it brought in new insolvency measures, some of them temporary, which only apply between March of this year to the 30th of September, and some of them permanent. The temporary ones are things like you cannot serve a statutory demand on a company anymore. Statutory demands are void. Statutory demands is a formal demand for payment of debt. So someone owes you money and they're not paying. You can serve a stat demand, and then the court can put them into liquidation if they don't pay. It's usually a very powerful tool for getting debts paid. That's off the table until 30th of September. The provisions in the legislation which make directors personally liable in companies are also off the table. So the court will assume that it's not the director's fault that the company is in financial trouble. So no wrongful trading provisions either. And in terms of permanent measures, what they've done is they've introduced two quite important permanent measures. One is this new freestanding moratorium, which has already existed in other countries' legislation for some time. I know that in America it's the same as what they call the Chapter 11 bankruptcy. But this is brand new here in the UK. It came into force on the 26th of June, so 2 weeks ago. And it means that it's a debtor in possession process. It gives the company a bit of breathing space. The directors stay in charge of the day-to-day running of the company, but there is a licensed insolvency practitioner who is the monitor, and he keeps an eye on it. And it stops people from putting them into liquidation. It stops enforcement of debts. It stops enforcement of security. It's designed to allow companies a little bit of time to work out whether they can survive or not. And then the other point is this supply contract termination provision thing, where the new act has stopped suppliers from relying on insolvency events to terminate contracts. And I think that came from when we all went into lockdown, the only reason that whole thing worked was because supply chains were preserved and suppliers had to continue to supply. And I think the UK government is thinking we need to make sure that suppliers continue to supply no matter what. And so it has put suppliers into a difficult position, because even though they know they're supplying to somebody who might go insolvent, they can't terminate. They have to continue to supply. So we'll see what happens with that. But it's all, big uncertainty in times to come. We'll see what happens.
All right. Very interesting, and definitely something that we should keep an eye on it, because, yeah, it's always, interesting in terms of the response to a lot of other problems, apparently. The way that they will handle this situation.
Mm-hmm.
Puneet, Diana has a very strong opinion about Singapore Convention. So I think that before I get back to Diana with a comment from our attendees about Diana, what is the India perspective on the Singapore Convention on mediation?
See, the India's perspective is a little more positive than what Diana's is. So India was one of the first signatories of the Singapore Convention. Now, I'll give you a little bit of background. In India, we view alternate dispute resolution as a better alternative rather than going to the court. In fact, in recent years, there has been a renewed interest in resolving disputes through mediation. And it will be interesting for you to know that all the courts in India have their own mediation centers. All the judges, before going into the merits, they tell the party to somehow utilize the services of the court-assisted mediation and resolve the disputes before litigating them. In fact, in 2015, we had introduced a Commercial Courts Act, where commercial cases over and above a specified limits are filed. So in 2018, we had an amendment which mandated a pre-institution mediation. So you have to compulsorily go into mediation, and only after the mediation fails, then you can institute a case in the court and litigate about it. Then even under the Companies Act, for resolution of Company Act disputes, under that, so we have a panel of mediators, a statutory panel of mediators that we can appoint and resolve our disputes. And as far as international ADR is concerned, very recently in 2019, last year itself, India has established a New Delhi International Arbitration Center to promote international ADR in India. And in fact, the New Delhi Center has had some cooperation agreements with the Singapore International Arbitration Center as well to promote international ADR. So in this background, our view of the Singapore Convention is quite positive, but yes, the efficacy will have to be seen once India ratifies it and brings in a law how to actually implement it. So in the past, as with the New York Convention, we incorporated it in our Arbitration and Conciliation Act. So there is a whole mechanism of enforcement of arbitral awards, foreign arbitral awards. And the defense to foreign arbitral awards is quite limited. So similarly, we'll have to wait and watch when the new legislation comes in wake of the Singapore Convention as to what are the defenses under which a mediation agreement can be assailed. So we'll have to still see the efficacy, but yes, the outlook is a little more positive than that.
All right. I will keep Diana on hold for a while and go to Samuel because I want to give you the last word, Diana. So let's go to Samuel again because I know that you are also practicing a lot with new technologies and the way that business law is getting more and more affected by the new technologies. Do you think that new technologies will play any significant role, and we are going to experience soon any sort of transition in corporate law, or what is your opinion about this? Because you spoke also about fintech before, and I'm sure you're familiar also with RegTech solutions, InsurTech solutions. So this technology thing, fits everywhere. So what's the transition phase for corporate law?
Yes, very interesting question as well. Technology is the use of technology is accelerating very, very fast in the last few weeks and months, and we will continue see that acceleration of the use of technology in the coming months or years. Definitely, corporate law will see these changes as well. As you mentioned, just for instance, the e-commerce. E-commerce has also seen an acceleration of use because of natural reason of these lockdowns all over the world. So e-commerce brings a lot of questions for corporate law as well. For instance, how are the commercial contracts going to be executed and perfected if you are not using any physical signature? If you are using only technological means, for instance, the e-signature, how is it valid in every jurisdiction, an electronic signature? For instance, in Mexico, there is a regulation for electronic signature, and as well in many other jurisdictions, there are laws and regulations regarding the use of electronic signature and e-commerce and all of that. Even though it's not new, as I mentioned before, this use is going to be accelerated, and it already is, and it will be even more in the future. So it's posing a lot of questions that we are seeing already. For instance, the use of electronic signature. Everybody knows that it exists, but now how can I use it? Is it valid or not valid? What are the requirements to use electronic signature? And then the most important issue is how I make it enforceable before a court of law. So this is a debate that is ongoing I would say, in Mexico and many other jurisdictions, I think. Some jurisdictions are already resolving this, but still, this is going, as in mediation and arbitration, I think we should find a global or international solution, because now these commercial contracts are not only executed between parties in the same jurisdictions. Now they are being executed in parties amongst different jurisdictions. Just for instance, the e-commerce, when you buy something in Amazon or on all these electronic platforms, their commercial address or the jurisdictions of these electronic contracts are not probably in your jurisdiction, are probably in some cases in the US or in some other cases in other jurisdictions in Europe, in Asia, everywhere. So most likely is that it's not going to be the jurisdiction in which you are located. So all this e-commerce brings a lot of questions and probably a discussion of how to unify this use of electronic signatures and all this technology, how it's going to be enforced by all the contracting parties, for instance.
Very challenging, definitely, and definitely, unless we start working on this and we see more and more things coming out, and you know, electronic signature and is becoming, you know, part of our daily practice. I mean, if you're not just for lawyers, but if you're a businessman or whatever you are doing, unless we see this happening on a regular basis, I'm afraid that it will just remain, you know, something which is we will see and see if it works, not be very, you know, be a little bit hesitant to see about the legality of the issue. Sometimes people still believe that electronic signature is just scan your your signature and put it there and copy paste on the paper, which is definitely not the case. But okay, I mean, challenging, of course, is also Diana's opinion about Singapore Convention. And because I see here a comment about Diana that she's indeed very energetic, so I'm not going to address any specific question to you, Diana. I'm just, the challenge for you now is a closing, you know, comment from you about this event is what we should expect in terms of mediation and arbitration, because to be honest, you know, for us, for every corporate lawyer around the world, we all believe that the core system is finished, more or less. All right. So people are looking for alternative dispute resolutions. We know that this will happen. We just don't know when. So it's a matter of time. So what we should expect? What is your feeling about this?
Well, first of all, don't get me started here. But anyway, I want to clean my name first of all. I'm not against the Singapore Convention. I just think that, you know, that there's some issues that have to be addressed sooner rather than later, because as Samuel and everybody else has said, we have fast forwarded in terms of communication and harmonization of laws, so we can move forward from this pandemic. And what I think is going to happen is that countries are going to be forced to unify the dispute resolutions, the settlements, so we can avoid going to court. We all already realized that it's a lot more efficient to do it outside court instead of litigating, which a little bit has to do with the Singapore Convention, and this is why I was like a little hesitant about it. But we have to catch up with the rest of the world, and the rest of the world has to pause for everybody to get in the same level and be in sync, so we can actually move forward as a whole and not having so many problems as to jurisdictions or national laws or institutional laws, but finding a more unified framework.
Mm-hmm.
I can go on and on for hours, but I know we're short.
I know, and it's clear. And well, I have to say that I really enjoyed our conversation. It was, I mean, huge pleasure for me seeing you all together and have this, you know, quick journey around the world. I'm sure that Puneet is gonna go for sleep in a while. Samuel, okay, just the day if you can. I don't know. Eleni, maybe we're gonna have lunch in a while or not. What time is that?
No, it's 5:30, so.
Okay, no, okay.
Yeah.
So it's a tea time.
Time.
Yeah. Tea time, yeah, exactly. No cake.
Yeah, no cake, yeah. Thank you all very much for this discussion. And I know that time zone is challenging even for people that they register for this event. That's why we promised to get, we have the emails for people that they register for the event, and within, I don't know, 48 hours, we'll make sure that at least we're going to send the link for the recorded version of our discussion. Enjoy the rest of your day. Enjoy tomorrow, Puneet. And I hope to see you all again and share more experience together very soon. Good luck.
Thank you very much for having us.
Thank you, everybody.
Thank
We got to
you
do it again.
Thank you, Harris. Thank you all.
Thank you.
Take care.
Guys. Bye.
Bye. Nice to meet you all.
Nice to meet you too.
Bye.
Bye.